You just pulled the trigger on your first subject to deal. The key's in your hand, you're about to have short-term rental income rolling in. But then you get a notice. The seller just filed for bankruptcy. Suddenly, the deal you thought you just had done might not be. And in the eyes of the bankruptcy court, you might not even own the property. But wait, you paid the seller. You've made all the payments. You've already furnished your Airbnb. But now, the bankruptcy trustee wants the property back. So what exactly do you do now? I'm Jeff Hampton, asset protection and real estate attorney, and owner of STR Law Guys and the author of the best-selling book, Investor's Blueprint, Asset Protection Made Simple. And in this video, I'm going to explain to you how a bankruptcy by the seller can explode and destroy your subject to deal. You'll learn what happens if the seller files for bankruptcy, how exposed you actually are, and the one document very few investors know about that could save you and protect you from this whole disaster. So here's the first principle you must understand. If the seller files for bankruptcy within the first 90 days of your transaction, then the court can actually undo the entire transaction. I'm not talking theory here. This is Section 547 of the Federal Bankruptcy Code. In legal terms, it's called an avoidable preference. You say, how is this possible, Jeff? Well, I want you to understand the trustee's job during a bankruptcy. The trustee in a bankruptcy's job is to look at any suspicious transactions, anything that might have happened near the filing of the bankruptcy that might make it seem like the actual seller who filed for bankruptcy was trying to avoid an obligation. And guess what? If you're the buyer of a subject to deal, right before the seller files for bankruptcy, you fit the profile, and now you're going to have that trustee eyeing your transaction. You say, wait a minute, Jeff, the whole deal was fair. Maybe you paid the arrears. Maybe you paid all in cash. Maybe you even improved the actual property. It doesn't matter, because if the seller files for bankruptcy too soon after your closing, the trustee has total control during that bankruptcy to come in, unwind, and undo the entire transaction, and you will have lost everything you put your money into. So don't forget the 90-day bankruptcy clawback. That means, number one, you lose the title. Number two, you might not get reimbursed for your improvements. And number three, if you've got renters or short-term rental bookings, cancel them. It's not your property anymore. Now you might be saying, Jeff, this has got to be rare. Well, it's actually not rare. It's just rarely talked about. So how exactly do you protect yourself? This brings us to our strategy. The strategy equals time plus structure equals survival. Your first defense in this situation is time. Make sure and confirm you're not doing a subject to deal within weeks of your seller actually looking to file for bankruptcy. You say, well, how do I do that, Jeff? Well, look for these red flags. Number one, multiple judgments. Number two, look for tax liens. Number three, look for collections or pending evictions. If any of these issues show up during your due diligence, you have a ticking time bomb ready to explode. But what if you get all of the timing right, but you miss out on how you structure the deal? This brings us to our second defense. You have to structure the deal just the right way. And I got to be frank with you, this is where most subject to transactions and investors, they just screw it up. They do everything informally. No note, no wraparound, no protections at all. But if you use a secured promissory note and a wraparound mortgage, everything changes. Which brings us to the wraparound note, your legal safety net. During a subject to transaction, when you create a wraparound note, the seller now becomes a secured creditor. You say, what does that mean? Well, in layman's terms, if the seller later files for bankruptcy now, the actual note becomes an asset in the estate. That means, number one, the trustee is more likely to honor the deal. Number two, you keep possession of the property. And number three, they can only now collect payments or sell the note, but they cannot sell the house. Compare that to a deal where the buyer is just Venmoing mortgage payments every month. And believe it or not, I've seen this happen many times. No contract, no protections. That's not even creative financing, that's gambling. Which now brings me to one of the most frequently asked questions I get from buyers on a subject to deal. What if the seller files for bankruptcy more than 90 days after the close? Usually, you're in the clear, but there are still traps that could grab you if, number one, you didn't record the deed. The trustee can dispute ownership. Number two, if you're related to the seller, it can be labeled insider dealing. And number three, if the trustee thinks it was a fraudulent conveyance, the deal could still be challenged. So yes, post 90 days is safer. But only if you get number 1, clean paperwork, number 2, clear value, and number 3, public record of the actual transfer. But there is one more risk most investors still never see coming. When the seller files for bankruptcy, the lender, he gets notified, and that notifies the actual lender that a transfer took place. Which means, in theory, the bank can now enforce what's known as the due on sale clause. Every residential mortgage has a due on sale clause provision in it. Unless you receive the actual consent of the lender, you cannot make any transfers of title, sometimes even option contracts on the property without consent of the actual lender. In theory, due on sale clauses are very rarely exercised, but I want you to understand the risk here. Even if the payments are current, even if the deal was done a year ago, now the lender is notified about this violation on your mortgage agreement, and technically they have all the legal right and maybe the financial incentive if you have a low interest rate to call your note due. So if you're sitting on a 3.2% fixed mortgage and rates are currently at 7%, you suddenly become very interesting to the bank. This isn't a certainty, but with subject to transactions, if things go south, you can guarantee the lender's going to be notified, so you better be ready for a contingency plan just in case. Which brings us to short-term rentals. And short-term rentals are amazing to use to finance subject to deals, but they come with their own unique risks. Why? Well, number 1, the value is often higher, which can attract trustee scrutiny during a bankruptcy. Number 2, improvements and furnishings may be lost if your deal is ever reversed. And then number 3, local licensing or revenue may be frozen if your ownership is contested. And worst of all, if things really go south, you may never get a dime of that investment back. So if you're doing short-term rentals under subject to transactions like the popular Pace Morby approach, here's some things you need to put on your checklist. Number 1, check for bankruptcy flags. Number 2, record the deed immediately. Number 3, wrap the deal with a note and a mortgage. And number 4, keep 91 plus days distance from any known distress. And number 5, always have a plan B just in case the bank calls the note due. Look, subject to deals are already an advanced strategy, but when bankruptcy comes into play, you're actually playing in the deep end. The number 1 mistake with subject to deals is assuming the deal is done just because you recorded the deed. This is real law with real risk. And we just covered what to do if the seller files for bankruptcy during a subject to deal. But did you know that there's a specific document you should file to protect yourself in a subject to deal? And don't even think about moving forward with a subject to deal until you watch this video. See you over there.